Okay, so we're going to start with chapter 13. This is week week 10. So we are now putting together all the pieces of what we've been studying all the way through chapter 13, where we're actually starting the research process. We're actually starting the process of taking a query, a question, and that's all a query is. It's just a fancy way of saying a question. Where an attorney gives you a query, and you have to go through the research process to make sure that you cover all the bases so that you can adequately, completely, logically respond to the query. Up until now, you've been doing just little research assignments to show that you understand how these research tools work. For instance, in Westlaw, figuring out what library to go into and understanding what a key site is and understanding how you can navigate that particular research tool. The same thing with the internet, going through some different research tools that might be available to you, understanding how they work. Now that you know how they work, we're going to apply that knowledge to more complex research issues or topics. Okay? Chapters 13 and 14 deal with broadly how do you do research and how do you write with clarity. Those two things are really important, right? If you don't have a foundation of how you navigate the research process, which tools you use, which libraries you use, which websites you use, then you're just kind of, rummaging through the forest. You have to have a clear path. There are some worksheets in this chapter that are useful, and we're going to go through those. But this is more of a broad idea of how you get from point A to Z, making sure that you hit every step in between. Because you don't want to leave anything out, right? You don't want to miss a case. You don't want to miss a statute. You want to completely answer the attorney's question, because what the attorney's going to do is take your research and then make future decisions on it. So for instance, if there's a client coming in the afternoon and the attorney's not real clear what the law is and wants to be really clear before the client comes in so that the attorney can appropriately advise the client, you may get a query to answer quickly, right? Client's coming in the afternoon, get this research done. Sometimes it's that way. Sometimes it's, got a client coming in 3 days. Can you please get this research done? The lawyer is going to base his or her decision on what to do with this client on your research. No pressure, right? So you want to make sure you are completely accurate in what it is you're looking for. You're going on a treasure hunt, and you want to make sure that you find every nugget along the way. Okay? Because if you miss something, the client is the one who's going to suffer, which means they're going to leave the attorney and the attorney is going to fire you. You got to do your research thoroughly, and you have to have a system for doing it. So let's get into chapter 13. So your book says, there are few inflexible rules in legal research. It's true. I can lots of times get the same information from several different sources. I might work harder using one source to find that information than if I used a different source, but as long as you get the answer, okay, we don't have to be rigid about it. However, even though there's no precise method to do this, there are steps that you need to know about, organizational tools that you need to have so that you can make sure that you properly solve whatever the problem is or properly answer the query. Okay? Your book says you should view legal research as a process. Okay? Although the answer to a question is the destination, you are traveling toward, there are many roads you can follow to reach that destination, like I just said. Okay, so you have lots of different roads you're going to travel. How do you know where to start? Well, the first thing that I recommend doing is kind of just doing a little worksheet. And, in journalism they say it's the who, what, when, where, and how. You have to answer all those questions when you are writing an article for a magazine or a newspaper or a blog or whatever. Same thing with legal research. Except you're not answering them in the end product, you're starting with them. Who is involved in this case? Who's involved in this matter? Are we dealing with corporations? Are we dealing with individuals? Are we dealing with government entities? Because that makes a difference in where you look for your answer. What are the issues? This is probably the hardest part of doing legal research. What are we fighting about? Or what does the client want? Or why is the client getting sued? What happened? Okay? The issue is the crux of what it is you have to research. Most of the time, there's more than one issue. And splitting those out is the tough part. Sometimes you'll think there's only one issue. You'll start the legal research and you'll start reading cases. And you'll be like, oh, there's more than one issue here. And you have to kind of go back to the beginning and start over again. When we get to 2 chapters from now, where we're doing legal briefs, we're going to practice identifying the issue that the court is trying to solve. And that's the same thing you're doing when you're doing legal research. Okay? Who, what, where did this happen? Did this happen in Ohio, in Pennsylvania, in Guam? Did it happen across state lines? Did it happen only in one state? Those are important questions because that's going to tell you who has jurisdiction over this. Where am I going to look for the cases? If this is a case about someone who traveled from Ohio to Pennsylvania, we know because of diversity of citizenship, right? Remember all the way back to the beginning lectures in this class? Diversity of citizenship, this might be a federal court issue. It's not going to be Ohio, it's not going to be Pennsylvania, it's going to be taking place in the federal courts, which tells me I'm not going to look at Ohio cases or statutes. I'm not going to look at Pennsylvania statutes or cases. I'm going to look at federal statutes and cases. I'm going to be in a different library. Okay? When did the activity take place? That can be important because we have something called a statute of limitations. So with a statute of limitations, we give people certainty under the law. If you have a claim against somebody, you have to bring it within a certain time period. And if you exceed that time period in bringing an action, you are barred, which means you cannot bring the action. You're barred by the statute of limitations. If you remember back to your civil litigation class, remember we put affirmative defenses in our answer to a complaint, and one of them always was plaintiff may have exceeded the statute of limitations. So knowing when something happens is important. If someone comes into me and says, I was injured in a car accident 4 years ago, I have to say, gee, I'm really sorry, but you only had 2 years to bring the lawsuit. So when the accident, when the case arises is important for that reason. Why did the issue arise? Again, that kind of goes with what happened, what's with the issue. What are the facts, really, is what we're saying. What are the facts that led up to this issue arising? Let's say we have a case where somebody puts a fence, a neighbor puts a fence on or too close to another neighbor's property. What are the facts that led up to that? Did the one neighbor say to the other, I don't really care, it's fine, put the fence where you want, Did one neighbor have fights with the other neighbor? Is there someone who came out and measured the property and there's been a mistake on where the property lines are? All of those things are important because those are the facts that go into how everything arose. Those are also facts that you're going to look for in your research. If you can find a case where the facts are very similar to your facts, chances are that case is going to help you. Or if it hurts you, you know where the law is. Okay? How did the problem arise? Can do the same thing as why. What happened here? What are the facts? Okay? You have to start, before you do any research at all, figuring these things out so that you know where to look for relevant law, either statutory or case law. What's the jurisdiction? Are we federal, state? Okay. You have to know all the underlying facts so that you can look for cases that are similar to yours. You have to know when it happened because the statute of limitations is important. Maybe they come in for a car accident case 1 year and 11 months since the last accident. Well, that's going to be important because you only have 1 more month to get everything done and a lawsuit filed. So these are important things that you have to look at. Okay? Then you start with, is this going to be a criminal case or a civil case? Now remember the difference between the two. A criminal case is where the state brings an action against an individual or a corporation because there is a statute in the code of conduct that says whatever behavior they did knowingly violates an existing statute. And someone can either be fined or lose their freedom. That's criminal. Now, if you're saying, well, what if I'm not working in the prosecutor's office? What do I care? Well, maybe a client is going to come in and say, hey, I got charged with a DUI. I got charged with an ERISA complaint. I got charged and I need someone to defend me. And so, it's important to know, don't look in civil cases, look in criminal cases, right? Don't look at civil statutes, look at criminal statutes. Okay, remember, civil cases, it's just money. People are fighting about money. That's what a civil case is. Okay? All right, and then the jurisdiction. Again, is this federal? Is this state? Is this going to be such a low dollar amount that we're in the court of claims or municipal court, or are we in common pleas court? If this is federal court, you know, which district am I going to be in? Because if I find a case that looks good that is in that district, well, that's the one that I'm going to follow up on when I do my research. Okay? Once you know those two things, you have to sort of get into the issues, identifying what the issues are, and then figuring out, well, if we're bringing a lawsuit against somebody because we've identified this issue and we want to bring an action against them, what kind of defenses will the defendants be able to make against us? Okay, if it's a dog bite case and a client comes in and says, I got bit by a dog. I was walking down the street and I went to go pet the dog and the dog bit me. And the dog wasn't on a leash. Well, if that's my client, I have to look at what the dog owner is going to say. The dog owner might raise a defense of, hey, your client taunted my dog. It's all perspective. And so I have to be ready for any kind of defense that the opposing party might bring against me, because if you don't anticipate it, you get blindsided. And then the remedies. What can be done here? Right? If a dog bite client comes in and says, Yep, I didn't do anything. This dog came up and bit me. No, I didn't go to the hospital. No, I didn't get stitches. No, I don't have an infection. No, I don't have a scar. You might have to say, well, I'm really glad that you weren't injured really badly, but because you weren't injured, you really don't have a lawsuit. There's no remedy for you. Okay? And that's another thing that you have to look at. So, that's all the pre-research stuff. That's all the prep work you got to do. Then you have to get into how to tackle the project. You're going to look back and you're going to figure out your descriptive words, your issues. Once you get into whatever research library you want to use, what are you going to research? Okay? If you look on page 516, and this again is in chapter 13. Let me see if I can hold this up so you can see what it looks like. There's a little worksheet. There's a little worksheet that you can use that sort of outlines everything that we just talked about. Okay? That outlines, okay, this is my starting point. Now I can start my research. So how do you start your research? Your book says go to primary sources first. I'm going to give a little caveat to that. What if it's a topic I don't know anything about? Nothing. Right? It's an ERISA complaint. I mean, it sounds really good to say ERISA, but what the heck is ERISA? Maybe I'm going to go to an encyclopedia. I'm going to go to AmJur. Remember that resource, that encyclopedia, American Jurisprudence? Remember the states all have, Ohio jurisprudence, Pennsylvania jurisprudence. Those are encyclopedias. So if this is ERISA, which is a federal issue, a federal statute, maybe I'm going to go to American Jurisprudence. I'm going to look up ERISA, and I'm just going to get some background on what ERISA is. Then I can start with my primary sources. But if I just start flailing through primary sources, I'm going to spend twice as much time. Remember, time is important. Time is money. Your lawyer is using your time and billing the client for it. And so you want to make sure that you are using your research time wisely. I'm a big fan of encyclopedias. Another great thing about encyclopedias is within whatever the chapter is you're reading. So if I'm reading about ERISA, there will be footnotes. And I can use those footnotes to go into Westlaw and start to do my research. Make sense? And honestly, I will share with you, when I first opened my research and writing business, I had an ERISA complaint. I had somebody who was being sued for ERISA. A lawyer said, hey, I need to file a motion to dismiss on ERISA. I need you to write it up for me. I'm really swamped. Sure, I'll do that. I had no idea what ERISA was. I went and I got some background, and then I went and researched. So I spent a little bit more time researching the background of ERISA, but in the long run, it helped me because I didn't spend so much time just kind of flailing around in the pool figuring out what was what. Okay? So once you have an idea, now you don't always have to go to encyclopedias, right? What if you work for someone who only does, intellectual property work, and so you know about copyright law, you know about trademark law, you do it all the time. You don't have to go to the encyclopedia. You can start right in your primary sources. Remember, primary sources are constitutions, statutes, cases. Period. Everything else is nice, but it's not controlling authority. It's not something the court has to listen to. It might give you, like the encyclopedia, not controlling. It's a secondary source. Okay? But because there are cases and statutes that are in the footnotes that are primary sources, when I look at an encyclopedia, I can lift those. I can lift those, carry them over, and do my primary source research. Okay? Now, your book talks about a one good case approach. You are always looking for one good case. What do I mean by that? I mean, I'm going to start looking for cases that have similar facts to what I'm dealing with. Our facts are similar. Sometimes you can find them nearly matching. And then I'm going to look at what the court did with those facts and law. Maybe the court says, you're out of luck. Well, I still have to know that, right? Purpose of my research is not to sugarcoat. Purpose of my research is good, bad, and ugly. So if it's really ugly and the court's like, forget it, I'm not giving you a dime, you're not doing anything, you are wasting the court's time, I better run, not walk, to the lawyer and say, look, this client might not be somebody we can help. On the flip side, maybe you find a case where the facts are very similar and the court comes out in the way that you would hope it would, that would help your client. Woohoo! Happy day! You will see lawyers or law clerks or students dancing when they find that one good case. I know you think you're funny. It's funny. It's true. I call it the nerd bridge. You have crossed the nerd bridge when you are so excited that you found that one good case that your whole week is lit up. But it's important. It's important for your job. It's important for your lawyer. It's important for the client. It's important. And let's face it, when you're looking for that nugget of gold and you find the gold, you're pretty happy. So that's what you do. Okay? Your book then says go to secondary sources. I'm not a great fan of secondary sources, again, unless you are using it on the front end to figure out what the law is generally, to pick up a few cases and then go forward. Okay? On page 522, it gives another worksheet that they call the research game plan. I'll put it up here if you can see it. The research game plan. Now, when you're first starting research, you can use something like this. It's actually really helpful so that you can keep track of what it is you've looked at, so that you can make sure, am I missing something? I want to make sure that I'm not missing anything. Okay? Then what do? So you're researching, you've gathered all this information. Well, first of all, how are you gathering the information? Well, let's say that I'm looking up cases and statutes and I'm using Westlaw. I can print out all of those cases, but that's going to cost my client a lot of money to print it. So lots of times law firms will have CD-ROMs with the actual cases. Maybe I'm going to have to take the citation, plug in the CD-ROM, and print from the CD-ROM, and that's fine. And maybe your law firm doesn't care. But you better have hard copies of all of your cases attached to whatever research it is, whatever hard copy of a response to a query you put together. Now, I know that sounds very 1989. You're going to do it in digital form too. But you want to make sure, if you're using West, that all those cases have gone into a folder so that the attorney can access that folder and read the cases. But there are a lot of lawyers who still prefer to have a hard copy of cases. So unless they tell you not to, have a hard copy of whatever case it is that you're relying on. Does that mean that you print out every case that you've read? Nope. Only the cases that you think are important for the lawyer to know on the status of the law, or on the status of what this particular client has, or whatever the query is. Because you're going to read probably 3-4 times as many cases as you need to read. You just are. That's part of the hunt. So then you have to organize your notes, right? I have notes on all of these cases. I've either put the notes in digitally, I've done notes in the margins of the cases that I've read and put everything into my folder in Westlaw. See how I'm going to the right-hand corner because that's where my folder is, right? Or I've done both. I've taken notes on paper and I put it into a folder. Whatever it is, you got to organize them, okay? It's hard. It is hard to organize all your thoughts. I've been doing this literally since 1985. Okay? Probably longer than you were born. I've been doing this. I like to use loose leaf paper. That doesn't mean I don't take notes in the margins on the computer and put them in the folder. I do. But I also like loose leaf paper because for me, visually, it's easier for me to organize my thoughts. A lot of people, of a certain age don't like using paper. Okay. Figure out how you're going to organize your thoughts. If you're going to take your notes that you put on the cases that you've read, copy and paste them onto something and then organize them around, that's fine too. And sometimes I do that, right? When I'm traveling and I want to get some work done, that's what I do, because having papers floating around when you're not at home is tough. So, whatever way is helpful to you to organize your notes is fine. Just recognize you have to do it. You can't just do stream of consciousness, okay? Your book talks about staying focused, okay? What I like to do is I like to, on a sheet of paper, or you can do it digitally, doesn't matter, put whatever the issue is, because lots of times there are 4 or 5 issues that I have to answer, all the cases that deal with that issue in one column, and then beside that in the column, what the ruling of the court was, the holding of the court. And I'll divide it good and bad, cases that were bad for me, cases that were good for me, okay? And then I'll number the cases. Oh, well, I kind of want to do this case first, this case second, this case third, fourth, and I'll put numbers. So then I know that when I address this issue, I'm going to do the cases in this particular order. That works for me. It might not work for you. And that's kind of the squishy part of legal research. I can tell you, you got to be organized. And you say, how? And I say, oh, this works for me. I can give you the framework, but you're the one who has to see what methodology works best for you. Understand the issue and all of the information that goes with that issue needs to be centrally located so that you can process the order in which you want to convey this information to someone else. Some people I know use use index cards, and that's easier for them, right? Some people will do it online. Like I said, we'll create a document and move stuff around. Okay, that works too. So whatever works for you, an organizational tool, just understand that the goal is that your thoughts are organized. Okay? How do you know when to stop researching? Oh, there is no good answer to that. I'm really sorry. I am really sorry. You go until things start repeating themselves. That could be 400 cases that you read. That could be 4. It just depends on the topic. It depends on how new the topic is, right? We just had the Supreme Court make a ruling on abolishing the decision set forth in Roe versus Wade, basically saying we are not going to recognize that the federal government has any role in terminating pregnancies, and the states can go back to figuring that out. Okay? Brand new topic now in the law. Every state in the union is arguing both sides of this. When do you stop researching? Brand new topic. You throw everything that you can find If I'm in Missouri, I'm pulling cases from California, I'm pulling cases from Australia, I'm pulling cases from wherever I can because it's a brand new area of law. For the states anyway. Okay? So, depending on what the topic is, you may be doing a bit more creative research and writing, which means it's a little harder to stop because there's really no repetition. But, you know, your book gives you these three things. You keep bumping into the same authorities, right? If you're researching a case and they're all referring to this one case, okay, it's probably time to stop. You've read the same point in a number of sources. There's nothing new. And your key citing reveals no changes to the law. Okay, so the law is what it is. And for most things that you have to research, that's what's going to happen. You'll know, okay, this is getting really repetitious. Stop. When you have new areas of law that you're getting into or novel arguments that you're making, you're probably going to research a little bit more. Okay? All right. Your book also asks the question, how many authorities are enough? And the answer is one. If there's one authority out there that is absolutely persuasive, if the U.S. Supreme Court said in 1943 that whatever is going on, that's it, and it's still good law, you key cite it, it's still good law, nobody's fought about it, one authority. Done. Okay? Most cases aren't like that. So you go until you get repetition. I would say that you actually can have too many authorities. Courts sometimes are like, okay, I get it. You know, the judge or the clerk to the judge that's reading whatever you filed with the court is going to be like, okay, you had me at page 22 and I'm now on page 75. It's enough. So you can be too repetitive. So there's a sweet spot in there where you have just enough cases that you're persuasive and not so many cases that you are kind of ticking off the judge. Because then you're not so persuasive. The judge is ticked off at you, let me just tell you, they're not persuaded. Okay? So there's a sweet spot, and a lot of that just comes with practice. Okay? All right. Then there are 10 tips for effective research. Actually, they're kind of helpful, so we're going to go through them. Be prepared, right? Don't start doing research when you know in 15 minutes you have to go do something else. Don't do legal research when you know you don't have a good Wi-Fi connection if you're doing it digitally. Okay? Make sure you have everything you need so that you can put the time and effort into doing research in a focused way. Be flexible. Okay? If you go down one road and you can't find it, try a different road. Be thorough, like we talked about. Know when you're starting to repeat things, you're starting to see things over and over again. Now you know you've pretty much exhausted that area of law. Be patient. I can't tell you how many times I would be given a research project and I would do work for a week and not find anything. By the way, sometimes that's just the way it is. You're not going to find anything. Not all the time, but be patient because you're going on a treasure hunt. It's going to take time. Be organized. Again, we've talked about that. But make sure that you put your time, organize your time. That's a big mistake that I see a lot of people make when they do legal research. You know, I'll do this tonight from 10 o'clock till 12 o'clock, till midnight. That's when I do my best work. They're asleep at 11:15. They're not doing their best work. be organized. Set aside a reasonable period of time. And by the way, lots of times you'll do research and you'll get really into it and you'll look and you'll be like, oh my gosh, that's 5 hours I just put in. But most of the time, you'll go for 45 minutes to an hour and a half and you're like, oh my God, I'm so exhausted. About an hour and a half is a good period of time to block off for doing research. Organize your time so that you have that block of time. Be efficient. Again, like I said, I like going to the encyclopedias first because it makes me more efficient on topics that I don't know about. For me, that is efficiency. And don't go down rabbit holes, right? Lots of times you'll be like, oh, that looks like a cool case, and boom, you're down a rabbit hole. And before you know it, you're nowhere close to the issues that you're supposed to be analyzing. Be creative. Again, if you go down a road and you can't find anything, think, where else could I find this information? Be wary. This is a really important part of the law. Really easy to persuade people who agree with you. It's harder to persuade people who don't agree with you. Play devil's advocate. Well, what if? What do you mean? I don't agree with that. The more you challenge your research, the better it becomes. Be resourceful. And the last one, be calm. I know, because I've been in those situations where a lawyer will say, I need this in an hour. I got to go to court in an hour. Let's go. If you're not calm in that 1 hour, you're not going to get anything done. Now, shame on the lawyer for doing that. But if you are calm and if you are organized, you might not get all the research done in an hour, but you'll hit the high spots. And you'll have something to give to the attorney who will be thoroughly impressed. So stay calm. Okay? All right, that's it for this chapter. I only put one assignment up for this week, but it's worth 50 points. So make sure that you do it. And it's a lengthier one. I could have split it up into 2 assignments. It's 1 assignment, okay? Plus you have a discussion. So make sure you notice that that's worth 50 points. We're getting into more extensive research. Projects are going to be worth a little bit more and are going to require a little more time. Okay? If you have any questions, of course, email me, text me. I'm happy to meet with you. I'm happy to Zoom with you. But we're going to start getting into some more complex legal research. So I want to make sure you have the foundation. Okay? All right. I'll see you soon. Thanks.